Mr. Harrison, in cause number 24 DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first-degree felony offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
No.
The motion alleges that you violated your probation. Count one alleges that you failed to report as directed on or about March 31st of 2026. Is that true or not true?
True.
Count two alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count three alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, I can abandon 4, 5, and 6. We can skip to 7.
Count seven, let's see, state abandons 4, 5, and 6. Count seven alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true?
True.
Count eight alleges that you associated with a convicted felon and disreputable person on July 13th of 2025, and that you were stopped by the Port Arthur Police Department with Gerodrick Randall, a convicted felon, and that he fled on foot while possessing a weapon. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 7, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Well, give me just a second.
Your question would be the underlying offense, Your Honor.
I'm just gonna go back and look at the PSI real quick.
He was one of 4 individuals that were breaking into cars. They got caught. One of them fired a shot at the person who confronted them while they were breaking into cars at a parking lot. Put everyone on probation. They've all come back, Judge.
I guess my concern is that there was obviously a gun and a shot in the underlying
I
offense.
do recall Mr. Harrison not being the shooter. I think we were able to figure out who.
But he's in another gun. I mean, another car with somebody with
Yes.
another gun.
And Mr. Randall's been revoked and sentenced to 8 years. He had a drug case, a new felony. So which is why his was a little bit more.
Look at something else. Do you happen to have the PC for that? The new,
For his new event, Daddy.
yeah,
I do, Judge.
thank you.
I also have the report from Mr. Randall's charges from the same stop. If you're asking as far as where going was.
Yeah, that's
Mr.
what-
Randall's lap as he ran from the vehicle and fell out as he ran.
Obviously, I'm just having some concern.
I understand her.
Yeah, Obviously, we're all over. Can't tell you how over we are with guns. And the fact that this is the second out past curfew with in a car doing whatever you're doing that you shouldn't be doing with another gun.
I will state, Judge, it was at about 6 o'clock in the evening. I don't think it was past.
Oh, it was?
No,
I'm sorry. I thought I read
well,
something
it's
about curfew. That
Not,
was
not this one, Your Honor.
okay. Thank you, Mr. Nick. I don't guess it really matters what time it is. And the other three that have already been revoked.
Mr. Randall received 8 because he was in possession of a firearm.
So was he one of the original
I think so, Judge. I do know that.
co-defendants under the underlying case as
I
well?
believe that's why he wasn't supposed to be hanging out with him. And then
That would probably
there's
be
a
the same. It'll have in here.
yes, Your Honor, he's one of the original
Okay,
one
I'm
of the
not gonna,
co-defendants.
yeah. Five's not, I'm not gonna accept 5. Not if you're already on probation with the same person for aggravated robbery with 3 guns in that car, another gun in this car. If he got 8, then I would consider that, but at this point,
We'll discuss it. Your
I'm
Honor.
over all of this gun stuff. So I'm gonna, I'll keep, I guess, the paperwork for now. If y'all come up with an agreement,
Yes.
otherwise it's a motion to revoke. I don't have to accept any agreements. It can just be up to me and we can have a hearing if we have to. But I'll just keep it for now. I can make an adjustment if you guys come up with something different.
Okay.
All right.
Thank you.
Go back.
The focus was no longer on promises or excuses. The court examined a pattern of behavior involving probation violations, drug use, and association with convicted felons. For the judge, public safety had become the central issue.
Morning. You are Aaron Wars.
Yes, ma'am.
Feeling better this week, Mr. Wars?
Ma'am.
So, Mr. Wars, this is cause number 25 DCCR 1253. Previously, you were in court, entered a plea of guilty to driving while intoxicated, 3rd or more, received that pre-sentence report and reviewed it. Have you both had an opportunity to review that report?
Yes, Judge. Yes, Your Honor.
In addition to that, we received an we received an update, also a memo from probation, I believe it was yesterday or late last week, and you both had an opportunity to review that as well.
Yes, Judge. Yes, Your Honor.
And so, any other issues, Mr. Smith? Obviously, based on the issues last week with Mr. Wars testing positive, there's clearly a need for some intensive treatment. Any reason though not to go along with the agreement still?
No, Judge, I think we would amend it because we did not have treatment involved. We would ask for safety placement. Your Honor, I've gone over with Mr. Wars and he agrees that he needs safety.
Okay. So Mr. Wars, we're gonna give you this opportunity today and I hope you take advantage of it. Because if you don't, things could be a whole lot worse. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find, sufficient evidence to find you guilty, and at this time, in accordance with your agreement, find you guilty of driving while intoxicated, 3rd or more. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation. That it will include entering and successfully completing the safety program. And then when you're out, you're going to enter and successfully complete the JCDI program as your aftercare. That will give you a longer period of time with more structure and drug tests and classes and things like that. You're also ordered to serve that 10 days upfront time. It's required by law. You'll be able to serve that while you're waiting to get taken to safety. And then any of the other conditions that probation feels like are necessary. You follow all of these and do everything that you're supposed to. This is a great opportunity because you'll be able to serve this 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you can be brought back into court and you would be facing that 10-year sentence that you've already agreed to. Do you understand? I don't see the certification attached to this one. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. All right, good luck to you, sir. You can go back with the bailiff.
I'll be able to see you, Jeff.
Good morning, you're Howard Walker Jr.
Yes, ma'am.
This is 26 DCCR 0082. Mr. Walker's charged with injury to a child, elderly, or disabled individual. It's a first-degree felony. What is the announcement?
Your Honor, we'd like to ask for one more reset. I've just gotten all of the discovery. Need to go to the jail and go through it with him. I think, Luke, Mr. Nichols agrees with me on this because he's got his.
I know they had to copy a lot of media.
Okay.
And so it's ready, and I think she either has it or.
I have it,
So.
But I haven't gotten to show him and I've only gotten about halfway through it.
Okay,
Quite a bit.
so we'll do one last reset. And so between now and that next court date, Ms. DeLays, you'll be out to the jail to go over everything, show you everything that she's received. And then we'll get an announcement at that next court date after you see everything, if you still want to go to trial or if there's some agreement that gets worked out. Okay. All right. We'll see you at the next court date.
Thank you.
Thank you. Good morning. Are you Eric Hebert?
Yes, ma'am.
And this, we've got two cases, 21-37340 and 21-37341. Both of those cases, Mr. Hebert is on probation and motions to revoke those probations have been filed. And what is the announcement?
Judge, if I may, he has a new DWI third. I've spoken with this officer, Ms. Kane, about that. I checked last week. It had not been received. Mr. Nichols was kind enough to check again this morning. The blood test results are in progress, or whatever that means. So I would ask the court if we could either go through the motion, see what pleas he will enter or hold for maybe 30 days just to allow that new case to come in. We had discussed safety as a possible resolution to pose to the court. Obviously, go with the new case outstanding. Obviously, the new case I will not dismiss, and obviously the court would want to see the new offense before you would determine if safety would even be an equitable option. So that's kind of where we are. Whatever you want to do, either go through it or reset it, and we'll stay on top of that new offense for March.
Oh, that's the agreement with the defense, yeah.
I mean, I don't guess it mattered. At some point, he'll have to enter pleas of true or not true. If y'all want to go ahead and do that, and then we can reset it.
I mean, that would help me expedite that case, but I don't want to put him in a position where he pleads true to it and doesn't get safety and thinks I've.
Well, that's gonna be, and I mean, if you're on probation for driving while intoxicated, third, and there's another one, I don't want there to be any thought that I will for sure go along with something like that. It's gonna take me looking at, I have no idea right now, but that just off the top of my head sounds like a big no, but I'll, obviously see the new case and look at what's been going on in this probation. I just, I don't want I don't think an agreement right now to that.
Your Honor, I understand that. I've spoken with the prosecutor. I've explained to Mr. Hebert the position that we're in, and that's not a part of the understanding that there's any
Right.
Agreement.
agreement.
No agreement. So it's just what you guys obviously
it was
would
just an
recommend. Sure. So do we want to go through the motion today then?
We can,
Or,
I'd rather have which one would expedite the,
A plea would, because I could push it without the lap, but if if, in all candor, if everybody wants all the information, just let me make a call and ask them to move it along.
All right. We'll just
Let's do
reset. I'll
that.
just do a normal reset.
Thank
Y'all
you,
See
hon.
if y'all can get that taken care of.
Yes,
All
ma'am.
right, and go back with the bailiff. Good morning. Are you Isis Martin?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
We got it.
Ms. Martin, in clause number 25, DCCR 1827, you're charged with the second-degree felony offense of robbery. And that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
You have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Martin's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. Mr. Smith, what is the state's position with regard to a bond reduction based on the nature of the
Have no
plea?
Yes, Mr.
I'm sorry.
She
He has
has
no criminal history. This is only arrest.
All right, so you don't have any objection to it? So, Ms. Martin, what I'm going to do between now and sentencing is reduce your bond to $1,000, and I'm going to make that a personal bond. So that means you don't have to pay any money. You're just going to get out of jail. But there's some very important things about that, okay? The first is that if you don't show up for court, then they can come after you for that $1,000. But that's probably going to be the least of your worries if you don't show up for court. If you don't show up for court, you run the risk of me not accepting the plea agreement, and things could obviously be much worse. The first thing you do when you're released from custody is go to the probation department. You're going to get some paperwork today from probation. It tells you where to go so that they can start that process to get that pre-sentence report done. If you don't go to straight there, you also run the risk of me not accepting the plea agreement. Do you understand that as well?
Yes, ma'am.
And then also a condition of your bond is that you have absolutely no contact or communication with Harmony Bodner. That obviously means in person, but it means any other way as well. So you can't send messages through other people. You can't send messages on your phone, by text or Snapchat or whatever else exists out there. Do you understand?
Yes, ma'am.
Do y'all live anywhere close to each other?
No, ma'am.
Okay, so there's no reason for you to have any contact with her. So you need to show me between now and when you come back that you can do everything you're supposed to, so I don't have any issues with putting you on that probation, okay?
Yes, ma'am.
All right, we'll see you back at sentencing. Gata Jr.
Yes, ma'am.
and Mr. Rojas, will your client waive the formal reading of the indictment?
You can go, Your Honor.
Mr. Sagita, in cause number 26, DCCR 0795, you're charged with the second-degree felony offense of burglary of a habitation from April 21st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and
Yes,
voluntarily?
ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 10 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. But as long as I stay within that range, you are giving up your right to appeal. Do you understand? I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them.
Yes, ma'am.
If we go forward this way, you're waiving that. Is that what you want to do?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, it looks like as part of that agreement, the state is agreeing to dismiss cause number 26 DCCR 0796. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Segata is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And the probation department will do a pre-sentence report. That'll give me more information about your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. Okay, you can go back with the bailiff. Good morning, sir. Are you Byron Jamal Morris?
Yes, it will.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Morris, in cause number 15-21651, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 21st of 2016 for the second-degree felony offense of burglary of a habitation, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of public intoxication November 6th of 2025. And is that true or not true?
That's true.
Count 2 alleges that you failed to report to the Jefferson County Probation Department for your administrative hearing December 18th of 2025. Is that true or not true?
Yes, Your Honor. True. True.
Count 3 alleges that you failed to comply with the curfew and that you were outside of your approved residence at approximately 11:59 p.m. November 6th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. Is that true or not true?
Not true.
Count 5 alleges that you're behind in your court-assessed fees as of January 14th, 2026 in the amount of $7,711. And is that true or not true?
True, Your Honor.
Did you enter your pleas of true to counts 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today.
Yes,
I'm
ma'am.
going to reset your case for sentencing so that the probation department can do an updated report. Also, so that the state can bring any witnesses with regard to counts 1.
The hearing served as a reminder that probation is an opportunity, not a guarantee. When violations continue to pile up, judges can reconsider whether that opportunity should remain. The final decision would depend on the evidence and the defendant's future conduct.